Agency is required, my lord. After question. But I had a word with him. Here. Might be informed about on his day for a
But what I required the presence of the Advocate General because he is the legal advisor of the state. But from the documents, I see that he appeared for one of the parties.
Yes.
So there is a direct conflict of interest.
That is why I do not want to say anything on his behalf, but for him to come and say whether he
No,
will
because
or he will not appear in the matter.
I was not very sure. And since he is the legal advisor, I requested his presence.
The thing he told me during lunch is that the Advocate General has been asked to
Yes, but it is
he will
the
go and appear and say whatever he has to say. That is what he told me.
I have followed it, but there is a direct conflict of interest.
But we have all seen those who are
I was not sure. And maybe when I passed this direction, I was not very aware that he was appearing for one of the parties.
Except for a review and a can, I never got a leader in the matter in any event. So
Yes, so you are there all along for the state. Whatever. I don't have any objection in you being there representing the state or anything. But then only had a senior officer been there, it would have been better. But with you also, I do not have any issue. This I make it very clear. For his presence, because I wanted the issue to be settled. There are various reports from where it can be, to some extent, we can understand that something has gone wrong somewhere. I had placed this proposal before the board. The board is adamant. They say they will not take any steps and they do not admit. But then 94 candidates were found to be appointed illegally. The investigation is on. Nobody knows whether the number will increase or not. And nobody also knows when the investigation will be over or not, when it will be over. In the meantime, or not. They are losing. In the meantime, their service years. Every day I am saying the same thing. So you as a state have to take a decision with what to do. 22nd of December. TET examination. Now these candidates who were there in the earlier occasion, I see you as the Advocate General. I do not see you in any other capacity. I was
either before your lordship or before the other things. And in fact, we are so far as Sujoy Krishna Bhatla is concerned, but I'm still appearing in another in one.
So your presence cannot be for the state in this matter, at least. This is what I was mentioning just now. That I just missed that you were there for the parties. I took it to be the Advocate General, the legal advisor to the state. But I am not getting the benefit of hearing submission from the legal advisor of the state in this matter.
Lord, may I say this, Lord?
Yes, please.
Lord, may I, Lord, authorize someone to submit on behalf of...
Certainly. In fact, I told Mr. Bandopadhyay that he is there from the very beginning. I do not have any issues with he appearing. He is already there. But then I wanted the legal advisor of the state's presence. But that, it's not possible. There is conflict of interest. And when the interest of the party and the interest of the state becomes the same, then it becomes very difficult to adjudicate the issue. Not only for the court, but also for everybody. Let justice be seen to be done. So, you are out by default. It's trembling.
Yes.
So today you are not there for the state. Are you for any other?
I am not
Very well. In that case, I'll hear what Mr. Bandopadhyay has to say. So have you followed what exactly is playing through the,
state vis-a-vis those who are out of service for the time.
not out of
Those
service,
who
who were
not been-
found to
who
be
have not got
unsuccessful
employment
in
at
the
all.
selection test? Because whether
Those
their selection is proper or not is a
vis-a-vis those
different
who were
issue.
found to be selected.
We are not touching that at now, right now, because the inquiry is still on.
But I completely understand what you're calling.
Yes. Something has to be done. Either you can take further examination. Most of them must have crossed the age barrier. That has to be condoned. Whatever was there at the time of the selection, the recruitment process, when they participated on the self same terms and conditions,
regular
let
selection
examination
process
has to be
conducted,
held.
not that
Let
everybody
them be given an opportunity and let things come out straight.
In fact, Muller, for some categories and for some classes, classes by classes I mean classes for which the teachers are to be appointed. Certain categories where there are pending. We found, as a state, we found that there were no litigations or pre-orders pending. So there, what we tried to do is that we tried to create supernumerary codes so that those who have not got the appointments and who are waitlisted, so there has to be some boundaries within which we can operate. So the waitlisted candidates can be incorporated into the talking about their service careers days. There also there's a interim order, so we could not carry it through. That was the line where the stance was till that point of time, and that was the last time when the question of supernumerary arose. Because there are certain persons, investigation is on the criminality aspect. As I explained. But unless there is a particular vacancy, another person cannot come in. The only resultant option to us is them or we can adjust it with future vacancies, etc. But that having been stated, I believe that the supernumerary angle has not been explored thereafter. Till that part, I can apprise you of the count today. Remaining, I'll have to talk to the senior executive come back with something to your lordship to address your lordship's query.
See, supernumerary posts, how many can you create?
Because exact I cannot say, it was 1,000.
Few thousand supernumerary posts. What it means, the supernumerary are more or less of the same number, then the vacancy goes on increasing in this manner. How is it possible that you create supernumerary posts for regularizing the appointments?
The vacancy is not increasing, but it can be said that
Posts are being created
for that particular purpose, which will extinguish with the cadre itself, himself or herself.
Yes, that means it goes on till the person attains superannuation.
At the same time, these various litigations which are pending, once they come to an end, I also do not know when that will be in the future, because of all these parties, they have their own contentions. The directions of the higher court which say that you hear everyone. In that scenario, if a vacancy is created in the mainstream, that person can be incorporated there from the time he is these days. It maybe or may not be a burden on the state. I do not know. That's a financial aspect to be addressed by the finance department. I'll speak to them. This is one of the solutions which we could have come up with, because again from our side, where in fact the statutory authorities who had removed, there also has been certain directions of the higher court that the courts must hear them first, thereafter remove. So that process will also continue. So, unless there is a vacancy, this person has to start their service immediately. Whether using their service career, using their days, using their seniority, etc., which we thought fit can be addressed. However, it has not met the end we intended it to. We could not substantiate it, legally. In any event, I'll come back to this task.
Yes, but then though you say that the state is not the appointing authority, which is true, you are also not responsible for conducting the recruitment examination or anything of that sort. But the authorities who are doing it are your parastatals, right?
State always is the parent battery.
So,
No matter which statutory authority is there.
absolutely.
But my intention of saying is that I cannot issue a letter saying that you vacate the.
True. And that you have not done also. That and the letters which were before me, at least, I do not know about the other benches, have been issued by the statutory authorities on their own. They checked up the documents and found them not in order. Steps have been taken. There may be similar other cases also because the inquiry is still on. So this is how I was thinking of at least put a quietus for the time being in respect of these candidates who are there voicing their grievances for quite some time. This can be one of the there may be other solutions also, which no one is being restricted to come up with a solution to the problem. But then I was thinking if it can be done in this manner, you all can think it over since you are the parent body.
What is calling from your lordship is a fresh process.
Yes.
Please state.
Right.
I remember, in the note sheet, one of the reasons considered was that since the last qualifying eligibility examination, another set of vacancies arose. Now, the eligibility field of eligibility also increased because a person during the last eligibility test, one who was 15 years old, became 18 in the name of like that. Another reason why supernumerary was vacancy is eaten us. That this you adjust something which has already happened. This person loses. His competition increases.
Yes.
So even to avoid that part, again I am saying this. What is right and what has happened rightly and what has happened wrongly will be decided in course of all these pending litigation. So the person who is becoming eligible, even as I am arguing before your lordship today, right? That person is losing out a scope as far as his field of competition is concerned.
Why is he losing out this scope?
Because a person who was supposed to be inducted in an earlier process.
Yes.
If everything was
proper. Yes.
That person has now to be accommodated in a new litigation.
Yes.
And earlier vacancy not because of the orders of the
Yes.
So, this person comes here and competes with the eligible
Junior ones. Junior ones.
Eligible candidates today.
Yes.
Unless inducted, no one is junior in age.
Yes.
But that was not supposed to be in an ideal section. And the fresh vacancy remains with the eligible candidates as on date. Without the requirement of any age relaxation, etc., except for those which are statutorily required or required because of the operation of law. That was another reason which was thought of. Because the entitlement to fresh vacancies were of some newer generation.
See, we are just discussing. That may give rise to problems. Why I tell you? Because you are shutting out eligible to sit for the recruitment examination. What happens if you do not shut? The competition, the zone of competition increases. Where 100 could have participated, now maybe 500 will be participating, isn't it? But then nobody can say by confidence that yes, I will sit for the examination and I will surely win it. That is also not done.
I'm not talking about those who are eligible as on date. I'm not talking about anyone who is eligible as on date. I am saying, for creating a class, some other relaxation may be needed to have not received their appointment letter. So
yes, that is required. Otherwise, it will not be possible. Yes,
one who is eligible today, whatever recruitment process, that person is anyway eligible.
Yes. So
I am not talking about then increasing the field of competition. That is not what
because relaxation will be required. Right. Especially the age and the
post will obviate that issue. That part, relaxation part. However, As I said, we could not justify it legally.
Mr. Bhattacharya, would you like to make some submission as to how the problem can be resolved?
Now, the 95 vacancies have been created because of about 95 persons were found to be illegally appointed. And the selection process which was undertaken then, by, out of which 95 were
waitlisting
appointed.
candidates.
Yes,
There is no
the
wait
merit
listing.
list, without the primary, there is no scope for waitlisting, but the original merit list, everybody was not appointed.
But the merit list was not published.
That's the point.
How can
Therefore,
you?
they have to produce the merit list prepared out of which the appointments were given, and the persons who could not be appointed, they should be appointed without in the vacancy.
Now, this is before the division bench. I do not know whether any order has been passed or not.
No, the division bench did not pass any order so far the recruitment is concerned.
The production of the list, there was a stay,
That
an
was
order.
stayed. That was stayed. And in one matter, it has been remanded back to London Single Judge to decide the petitioner's claim and then issue order. This is the position.
Is it before this bench?
No.
It's
the other
before some other bench.
Justice Ganguly had passed an order, similar order, asking for production of the merit list, which was challenged. The division bench said, let the court decide the eligibility of the person who has moved the court and
He
then
was
pass
carried
the order.
from the order
Therefore,
passed
as
by this
remanded
bench
back,
also.
that is, so far that
Pending.
part is concerned state.
So it is pending. So without going into the 95 vacancies, as you say, what about the
95 persons
others?
could be accommodated.
So what about the others?
The others we have to wait without till without
If
this.
you keep waiting, it will be an unending wait.
No,
Why
without-
wait?
I don't think that it will be unending
As
because
we
without
suggested,
now
remand the matter
the
back to
Honorable
the
Division
Supreme
Bench
Court
here.
on our
And
last
Division Bench will decide in the time schedule framed by the Supreme Court. Therefore,
Is it in the primary case or the secondary case? also?
secondary case order has already been passed.
That has been
And
passed.
this is the proposal in the primary also.
So if that be so, then this bench will hardly have any thing to decide in the issue apart from the investigation
Yes,
portion.
yes. This bench will decide on the question of investigation.
Yes.
And if the Honorable Supreme Court will not fix it to remand before the Division Bench on the question of illegality of appointment, then the Division Bench will decide in the time schedule framed by the Supreme Court.
Then it hardly makes a point to direct the authority to, especially the state, to
Well,
find out a solution.
At this stage, I think the authority would also not be able to give any suggestion.
It will not be possible.
Milord, if a bench, if the Honorable Supreme Court directs that binding matter is appearing in more matters than I am, but there are several appeals from this matter also, these two matters.
That is the reason I was saying that this.
So a part of the writ petition cannot remain here. The entire writ petition will go before that bench.
No. There are two parts of this. One is
One
Writ
is-
petition parted.
I do not know what is the order.
that the issue would be, but let us not discuss here. The Supreme
Yes,
Court-
because the SupremeUrt, if the Supreme Court is in decision of the matter, then the court will take a decision.
Milord,
যারা পেতে পাশ করেছিল তাদের
Apart from
তুমি একটা
I understand there is no order from the Supreme Court as of now.
no.
No, they are
Proposal.
whatever. If it is
No, again, Milord, the problem is that that relates to 269 candidates. Now, so far the rest part of it, 33,000, that is now pending before the division bench, where the division bench was going to hear out about the validity of the appointment, right?
if that be so, then what is to be done now over here?
But now,
How
so
is
far the
the-
appointment is concerned, I think my lords have little choice to do.
Yes, then
এটাকে accommodate কিভাবে করা যাবে জিজ্ঞেস করছি।
এখানে এখন করা যাবে unless that is decided.
all discussions
না 94 এর ক্ষেত্রে
Gone to
decide
waste.
করতে পারে 94 ডিসাইড করতে পারে স্যার
94 তো বোর্ড মেনে নিয়েছে অ্যাপিল ডিভিশন বেঞ্চে ডিসমিস
এখানে যশা বলছে লিস্টটাই নেই তো 94 করতে
না না
And for the panel, again we go back to that argument that they
Accept
did
করে
not
বলছে
complete the panel. Then the-
95 vacancies has been created because of termination of 95 candidates. Now the question is whether the list, merit list, out of which they will be appointed. That's the question.
এবার স্যার যেসব ক্যান্ডিডেটরা এলিজিবল কমপ্লিট করেছিল তাদের ইন্টারভিউটা
Not the fresh process করতে হচ্ছে।
where is the ED? Behind the screen, I couldn't see you.
No, I'm
Any report?
Yes, well, that I can.
Very well, give it, I'll peruse it. And in the meantime,
Acha, Madam, let me have a thought over it.
in
and
the
come back
meantime,
to
if,
my suggestion.
please
If
do.
my learned senior wants to convey anything to me.
No, your learned senior is saying that he will participate in the meeting,
Ah.
that he is going to,
Okay, Boshin,
yes.
let
So
let's
please
sit
sane
together.
heads,
Benevolent approach.
sane heads,
Hmm.
look over this and not leave
Right.
this to somebody
sane
else.
people should
Who
decide
just
this
do
issue.
not know how to handle these things.
Well, all the Brahmins will create the trouble.
I am a non-Brahmin, I tell you.
And one Muslim is there.
Anyway,
Yes.
One in the
Way of
universe
looking at
having
it.
gyan
I
about
mean,
Brahman.
Manusmriti also says that. Manusmriti also says that. It has been misinterpreted that only Brahmins, and I don't want to go on my.
who is Brahma?
Sealed
Their
cover
question
is
is
taken on
asked.
record. Report filed by the
Stop.
enforcement director. The court is yet to peruse the same. When will the next date be fixed? When will the next date be fixed? Sometimes in February? Because
এই সাজেশনটা
Suggestion পেলে mention করে করে দেবে।
16th এ রাখো, in the meantime বসে যাবো, বা 17th।
no, I don't think it can be done so fast.